Hello, my name is Jutta Croll. I'm the chairwoman of Digital Opportunities Foundation in Germany, where I'm also managing the project Children's Rights in the Digital World. Within the next 15 minutes, I would like to introduce you to a child rights-based approach to the amendment to the German Youth Protection Act. And going further, we see that there are two references for a child rights-based approach. First, obviously, is the UN Convention on the Rights of the Child. And also we have the Council of Europe guidelines to respect, protect, and fulfill the rights of the child in the digital environment. Looking at the UN Convention on the Rights of the Child, we see in the focus the primary principle of the UN Convention, and that is laid down in Article 3, which reads, "In all actions concerning children, whether taken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration." This is also sustained by the European Charter of Fundamental Rights in Article 24. We have drawn up a triangle of protection, provision, and participation based on the UN Convention. And you can see that in these three corners, we have various articles of the UN Convention that fit under protection, provision, and participation. Article 17 is addressing the access to information and mass media, but also youth protection in the media. We have in Article 32 the right to be protected from child labor, in Article 34 the right to be protected from sexual exploitation, Article 19 protection from all forms of violence, and, of course, very important in the digital environment, the right to privacy as laid down in Article 16. On the other hand, we have rights to provision. First to be named the right to education in Article 28, but also freedom of expression, Article 13, and again access to information in Article 17. Based on these two cornerstones, we have in the head of the triangle participation. And here the most important is Article 12, the respect for the views of the child and all matters that affect them. We have also the right to freedom of association in Article 15, and the right to leisure, play, and culture, also performed with digital media, of course, laid down in Article 31. I'm coming now to the Council of Europe guidelines. The Council of Europe regularly implements strategies that shall help to implement the UN Convention on the Rights of the Child. The current strategy was set up in Sofia in 2016. It lasts for 5 years. And for the first time ever, the digital environment was set as a fifth pillar beneath equal opportunities, participation, life free of violence, and child-friendly justice. The Council of Europe have set up the ad hoc committee for the rights of the child, which is called CAHENF, and then in addition the so-called CAHENF IT, a group of experts from 7 European countries which have drawn up these guidelines. And the guidelines were adopted as recommendation from the Committee of Ministers in July 2018, so they have come into force. Let's look at the purpose of the guidelines of the Council of Europe. And you see under the first point that they shall guide states in formulating legislation, policies, and other measures to promote the realization of the full array of the rights of the child. So we can take this as a reference for new legislation that is necessary in these times of digitization. It's a fact, children are growing up with digital media today. And if we have in mind the principle of the UN Convention on the Right of the Child, that states and all other stakeholders should act in the best interest of the child, we can take these two pillars, the UN Convention, the principle, but also the fact that children are growing up with digital media, as a task to have an amendment to the Youth Protection Act. Let's have a look now at certain articles of the draft amendment. First, I would like to mention Article 10A, which names the objectives of the protection of children and young people. And we already have there in the Youth Protection Act that protection includes protection against media which are capable of impairing the development of children and adolescents. Also, we have the protection against media which are suitable for endangering the development of children and young people. These are set objectives in the German law. But in the new amendment, we have also, under 3, the protection of the personal integrity of children and young people in their use of media and in the media. And that is due to the fact that this personal integrity might be affected, especially by interaction, by contacts that children are performing via media in their use of media. So, what can be done with regard to achievement of these objectives? When we look at Article 24a, we can see that there are precautionary measures described, and these follow the principle of duty of care. Article 24 is directly addressing service providers, and it lists under point 2 some of these precautionary measures and what they can be. First of all, there is named the provision of a notification and redress procedure by which users can register complaints towards the service providers. Secondly, it's mentioned that these reporting and redress procedures should be accompanied by user guidance which is suitable for children and young people. Then we have named the provision of a rating system for user-generated audiovisual content, the provision of technical means for age verification for user-generated content, but also easily to be found references to provider independent advice, assistance, and reporting facilities like hotlines or helplines, for example. Then under 6, parental controls are mentioned, and under 7, very important, the provision of default settings which limit the risks that children and young people can face in using diverse media platforms. Last but not least, terms and conditions shall be held in a child-friendly manner. So if we have all these precautionary measures, of course, we also need a body who is tasked with the review and the monitoring whether these precautionary measures are implemented and maintained in an appropriate way. So therefore, the amendment to the German Youth Protection Act suggests to implement a federal agency for youth protection in the media as a new body. And if you look at the list of tasks, you will see that under point 3 also, the regular exchange of information with institutions active in the media, in the field of protection of children and youth in the media, is established here. And that is an approach of dialogic regulation that is also new in this amendment to the German Youth Protection Act. It is further said in Article 17a that the federal agency shall review the precautionary measures that are to be maintained by service providers pursuant to Article 24a. Then this should be reviewed, and the federal agency shall do so and have a look whether the service providers have set up with voluntary self-regulation organizations a so-called directive. So, and this directive shall lay down how the measures shall be implemented and how they will be maintained appropriate to children's and young people's needs. there is a fourth pillar of this child rights-based approach, and that is the participation of children. And it's laid down in Article 24c that the voluntary self-regulation organizations shall let children and young people participate in setting up such a guideline so that their concerns are to be taken into account in an appropriate manner. To summarize this, I would like to refer to these four-step approach in regard of child's rights, and that is, as mentioned before, the protection of personal integrity in Article 10a. Then we have the precautionary measures following the principle of duty of care in Article 24a. We have a dialogic regulation approach with the Federal Agency for Youth Protection in the Media in Article 17. And last but not least, we have the participation of children laid down in Article 24c. This is a very new approach to legislation for the protection of children in the media. And it is somehow based on the approach of the intelligent risk management. Some years ago, the German legislative system to youth protection in the media was evaluated, and there the term of risk management was coined, which is, when it's done as an intelligent risk management, an approach that consists of a variety of different measures, including various stakeholders in their respective role. If you look at this graphic, you will see that the state is there with a certain role setting up the regulatory framework, but also on the bottom of the graphic you will see the internet users, the community of users, which have also their role to play. The system differentiates children in 4 age groups, which is children under the age of 6 years, where as much as possible risks should be excluded. Then we have children aged 6 to 9 and children aged 9 to 12, where we somehow come from the objective of risk avoidance to risk reduction for the oldest age group, children aged 12 and over. So, and in all these age groups, we have different instruments. In younger age groups, we can more rely on technical instruments, like they were mentioned under the list of precautionary measures. For the older children, we would need more instruments like terms of reference, understandable for children, but also instruments where they can file complaints in regard of their rights that might be infringed by other users or by uploaded images and so on and so on. So it needs the whole system to come to a holistic approach to child protection in this new world of digital media and digitization. Summing up some perspectives, we would say if you base legislation on this triangle of protection, provision, and participation, this can be referring directly to the UN Convention on the Rights of the Child. Contemporary child protection, as said before, must account for the fact that the digital world is inseparably linked to the world of children and young people who are growing up today. We think it's not necessary to define new rights for children that are aligned with digitization. Rather, it's necessary to have a look at the articles of the UNCRC and then to gain a more comprehensive understanding of the rights granted to children, taking into account the digitization and the new developments. There is a general comment to the UNCRC underway, which relates directly to children's rights in the digital environment, and we assume that will be adopted at the beginning of 2021, and it also will support the approach of the German Youth Protection Act amendment. In case you have any further questions to me, please do not hesitate to contact me at the email address provided on my last slide, I would very much thank you for your attention, and hopefully you will get back to me with your questions. Thank you so much, and enjoy the EURODIG within the next days.